Welcome, everyone, to the PI Playbook Podcast, a show where I get inside the huddle with successful personal injury attorneys and find out what's working in their firm and where they're going forward. I'm really excited about today's conversation. I'm joined by Ben Price, partner attorney at Jarrett Price, LLC in Georgia. Ben's practice focuses on personal injury law, but what's particularly interesting is how he and his firm have become go-to experts for other plaintiff attorneys who need help navigating the incredibly complex world of ERISA healthcare liens and subrogation claims. This is one of those areas where you can win a great settlement for your client only to have a huge chunk disappear to healthcare plan reimbursement, unless you know exactly what you're doing. Ben has literally saved plaintiffs millions of dollars by knowing how to defeat, reduce, or eliminate these liens. He's a frequent speaker on the topic. He's published in legal trade magazines, and top plaintiff firms across the country hire Jarrett Price specifically for this work. Ben, welcome to the show.
Thanks, Adam. I appreciate it.
Let's start with how you landed on healthcare liens and ERISA as a focus area. This isn't exactly the first thing that comes to mind when most lawyers think about personal injury work. So what pulled you into this niche, and when did you realize there was a real business opportunity in helping other attorneys navigate this problem?
That's kind of an interesting story. The reason is I got out of law school in 2011. If you recall, there was a major recession in 2008, 2009, the years I was in law school. And we had my law school class, people were lining up, wearing their suits to campus every day to interview with Troutman Sanders and all these big firms in Atlanta. I went to Georgia State. And people were getting their offers rescinded left and right. There was nowhere to go work in 2011. Very, very few people had offers coming out of law school. And I was working with a attorney's office, sort of a general practice place that was doing some personal injury. And I had worked there for a couple of years, just helping them with their personal injury caseload. And I was assisting a really great attorney and a mentor of mine named Bob Coleman, who's in Gainesville, Georgia, and is a great lawyer. He did family law for years. He does a lot of personal injury now. And he was having this problem of, what in the world are we doing on these cases when the healthcare company's saying, hey, congratulations on your $100,000 settlement. We're owed $50,000. And so we had to figure it out. And it was just kind of one of those things I was doing. I was still in school. I was a law clerk. So I had to kind of do a deep dive into this. And it was one of those things where the law had recently changed in 2000 and around the year 2000 to 2006, there were some Supreme Court cases that had given the healthcare companies the green light to go ahead and get reimbursed when for decades prior, they'd really had no hope. Okay. So it wasn't something that lawyers who had 40-year PI practices were used to dealing with. It was sort of a new problem. And so I had figured it out for Bob and was doing it for him and realized when I got out of law school, I didn't have a job. And so I had to go find a way to make some money. And I went to one of my professors was basically he was an adjunct and he had a practice in Athens where I was living at the time. And I went into his office and I said, hey, how about I help you with your healthcare liens for, a few $100s to look into the healthcare plans. And if I can save your clients any money, give me 10% of whatever we save them and get your clients to agree to that. And he said, absolutely, let's do it. And so I did that for him on a couple of cases and it went pretty well. Saved one client a lot of money and the other client, we didn't, but I saw, okay, well, if he's willing to do that, let's go reach out to other people. So it was kind of how I started my practice from the beginning. I was only doing healthcare liens. And when I moved to Savannah, it was sort of the primary way we were getting into the PI world because we were talking about this before we got on the line. It was extremely expensive to get into personal injury. The advertising cost, you're competing with billboards, you're competing with pay-per-click on Google that's $200 a click. We were bootstrapping a new law office and my partner and I, who I'm still partners with, Patrick Jarrett, we were in a $250 a month office. His was $250, mine was $250. So we were paying a total of $500, and we were just trying to get any kind of cases we could. We didn't have any kind of money to advertise. And so it was very easy to go to these personal injury attorneys and say, hey man, when you settle a case and you've got a $300,000 healthcare lien, let me look into it for you. And if we can save your client some money, we'll make some money. So that was really how it started. It was sort of the only thing I knew how to do when I started a law practice. And it was 2011, 2012. I had no choice but to start my own practice. Everybody I knew was just having to hang a shingle. And so we did it for years. And over time, I just kind of built relationships with attorneys. Honestly, we could do it a lot more of it. I didn't want to look into healthcare, be reading healthcare plans all day. So we had a very busy family law practice, and then eventually transitioned more into personal injury once we had the budget to get the cases. We now run about 200 cases a year. So, but we still get calls regularly from PI firms with questions about these healthcare liens and if there's any way we can help the client. Caveat to that is there was a decision in around 2012 where the U.S. Supreme Court kind of cut our legs out from under us on the plaintiff side. Basically, it said if the healthcare contract has the appropriate language in it, there's nothing you can do about it. You just don't have any arguments. So we never really went full tilt for the healthcare lien resolution because we started 9 times out of 10, we were having to pay them back. And so we just didn't have the opportunity to make a lot of successes for our clients. So we basically were just reviewing healthcare plans going, yeah, you're probably going to have to pay it back, see what you can do, see if you can get them reduced 15%, So that was kind of the journey. But still, when you can save money, you got to save the client the money. I mean, if there's problems with the healthcare plan reimbursement, whether it's the way it's funded, whether they don't have the proper contract language, somebody in your office needs to know something about what to look for, or go ahead and call somebody like us or another company to make sure that you're as positive as you can be about the enforceability of the healthcare's lien before you pay them a chunk of your client's money. Because sometimes they can be, $500,000. I had one last week that was $2 million lien.
Oh, wow.
Unfortunately, it has to be paid back.
So it sounds like that's no longer really a primary aspect of your firm or your focus now.
No, I'd say it's about 10%. I think there's an opportunity there if somebody really wanted to embrace it and make it their primary practice. I know John Caddy has done a lot. He's down in Florida. They do a great job. They started in the Medicare world. There's not a lot of opportunities to win these cases, right? I mean, something has to be wrong, and usually it's the way that the healthcare plan is funded that's going to win you the day. And in Georgia, we have a very helpful plaintiff-friendly statute that says you only have to pay the healthcare plan when your client's made whole. The problem is that if it's self-funded by the employer, which is the way most healthcare plans are set up, then they're exempt from those rules. There's just preemption, federal preemption applies, and basically you go by what's in the contract. And by now, after 20 years of healthcare plans collecting billions of dollars a year from plaintiffs' attorneys, they make sure those plans have every safeguard possible in them when you read through them. So if you're not winning on funding, you're probably not winning. Occasionally you'll see and when you see like healthcare plan documents that say 2015, like it's last updated in 2016, you might take a hard look at it. But if it's a fairly recent one, you're probably going to win. But one caveat on that, I will caution everybody. If your clients are purchasing healthcare off the healthcare exchange, make sure you're asking that question, because that's one of the places that we win. When you're purchasing that off the healthcare exchange, that is not employer funded insurance. Obviously, it's not coming from an employer. So state law is going to apply. If you are just going through an insurance broker to get you set up with some insurance, which ultimately is now on the exchange, those are ones you can win. And we still get county employees and government employees that are for local governments where we can defeat the liens. For large corporate employers, just not a lot you can do there.
Interesting. Okay, so that's about 10% of your practice, and the rest is personal injury and
Yeah, I'd say, excuse me, about 90% of my day is working the personal injury caseload with our team. And we will review healthcare plans, usually on larger cases. There's med mal attorneys that have they'll get a $40 million wrongful death settlement, or they'll get a very large settlement. And part of the reason it's so large, there's a huge amount of medical bills. And, we'll have a $2 million lien or something like that. And that is a source of a lot of our business, or the catastrophic injuries where the healthcare liens are huge. The ultimate settlements and verdicts are huge, but there's also very large amounts of money at stake as far as whether the healthcare lien is enforceable or not.
got it. So essentially, kind of what I'm hearing, and correct me if I'm wrong, but the only time or the majority of the time that this ERISA and healthcare liens come up are on the really high dollar complex med mal cases, things like that.
Not necessarily. I mean, there's some people that will call us all the time. I mean, we usually can take a review of something for 10 or 15 minutes and just kind of do that. Is it gratis, or maybe just a few $100s just to pay us for our time to review a plan. That's it. What I tell people typically is, let me tell you what I see. You can take it from there, but I'll tell you 9 times out of 10, when it's employer funded healthcare, I mean, if you tell me, hey, I've got a county employee that's a teacher in the public school system, I say, great, you're not going to have to pay it back. I mean, I only have to look at it, right? And so they go to them and say, hey, we don't have to pay this back. And they say, no, you still have to pay it back. Well, call me back, and then I'll get involved, and we'll see what we can do, and we'll work out a fee. If it's a smaller lien, we'll just work out an appropriate fee. If it's a larger lien, we'll typically do it on a percentage. Clients usually, when they have money that they can't access, and it's like, $10,000 or more, they're usually pretty willing to pay somebody $1,000 to go in there and free up $9,000, $10,000.
Sure. Is there any specific Georgia statute that deals with lien repayment?
Yeah, and that's important because not every state has one, and not every state has a good one. We have a great one, 332456.1. It's a great statute because it's all very condensed. It deals nothing with anything but the rights of a plaintiff when they've been in an accident and when the health care plan or disability plan can get reimbursed. And it basically says that you only reimburse the health care plan when the client has been fully compensated. And it also has a provision in there that says any information in the contract, any terms in the contract that are contrary to that statute are unenforceable. So it is airtight. When you can get that plan to be subject to that statute, you win. When you can't get the plan to be subject to the statute, you very rarely win. And it comes down to whether you can apply, we call it the made whole statute, and there's also a case that came out in 1999, and it's Kaiser v. Davis. And the Georgia Supreme Court said shortly after the adoption of that statute that this is the public policy of the state. It's the declared public policy that a plaintiff does not have to repay their health care plan unless they've been fully compensated in the accident, or i.e. made whole. And nobody's ever made whole because you have to pay your attorneys. You have to pay the lien. You have to pay, and it's like, after all these deductions are made, is the person still fully compensated? Well, you'd have to get a real windfall to be declared fully compensated. Another place we do save people money and is wrongful death claims. There's case law in Georgia, the way our wrongful death statutes work, that the wrongful death proceeds, not the money going to the estate. Most wrongful death cases in Georgia, as you know, we have the full value of the life of the decedent, which flows to the spouse or whoever's next in line of theirs if there is no spouse. That flows directly to them. It never flows through the estate. So the health care lien and the debts of the decedent, none of that can be touched by the wrongful death proceeds. It goes directly to the wrongful death beneficiaries. Anything you put in the estate is subject to the healthcare liens or any other debts of the decedent. So how you settle out your case really matters. If you've got a large amount of healthcare bills and whatever, I mean, not healthcare bills, but medical bills, and therefore there's a large healthcare lien, you may want to not put much in the estate, maybe put just enough in to pay back some of it. There's some case law that says you can put $1 in the estate. We've had cases where people haven't brought in an estate claim at all. I think you do need to bring an estate just so you can settle it, so that it's not an outlier. Most of the insurance companies are going to want to have settled it, even if it's for a nominal amount, so it can't come back in the future. But we do quite a bit of consulting with people when they're settling out wrongful death cases to make sure that they're limiting their lien exposure as much as possible.
Interesting. So on those wrongful death situations, is it other attorney offices that will call you because they know that you're the kind of the expert in this particular area of the law, or how are those calls?
Yeah. I mean, typically we get called because we speak a lot on it. We'll do everything from Georgia Trial Lawyers Association. Sometimes we'll do attorneys that have educational podcasts and things like that. Jeff Shiver Hamilton has probably referred more business to us than anybody else over the last 15 years. Jeff and I, he was working with me when I was back in that $250 office. He probably didn't know I was in a $250 office, but when I was really, struggling to get off the ground, Jeff had some massive cases and was calling us left and right to help him with healthcare liens on this. And, he's invited me to speak at his, on his, he does an educational podcast and YouTube type channel, or some CLEs and things like that for other plaintiffs' lawyers in the state. And we inevitably get business from those.
So you and Patrick have had a firm since 2013. What's that, 15 years now?
Going on. It's getting close. I think the firm itself started in 2009 when it was just Patrick. So I think last year we celebrated our 15th year. I joined, he was a solo, and then we started Jarrett and Price on January 1st, 2013. So we're coming up on our 12th year. 13th year. Never been good at math.
Me neither. That's why we went to law school, right?
That's why, old Joe, that's why we went to law school.
Yep. So how else has the practice evolved? You mentioned the healthcare, and that sort of dried up a bit, at least in terms of the changes that they've made. How else has your firm evolved kind of over the last going on 13 years?
I would say the biggest change happened in 2020 when we all had to go home. And there also was a period of time when it wasn't clear whether the insurance companies were going to be open, and therefore nobody was going to be mailing out checks. So for anybody who didn't live through it or is unaware, when the COVID shutdowns happened, the Georgia courts closed for, I believe, 120 days. I think it was more than I think it was 126. So there was a 4-month period where absolutely there was no way to resolve a case unless the insurance company just wanted it resolved. And I can remember having a phone call with somebody, I think at Georgia Farm Bureau, and we had a check coming out. And this was like, we're packing our stuff to go home, right? Clearing out the office. There was nobody on the roads. This is March of 2020. And we said, are y'all going to be writing any more checks? And they said, we're not sure. And I can just remember a chill going down my spine when I heard that. I was like, oh my God, these settlements are how we pay for everything. If the settlements aren't coming in, what are we going to do? So, we got out of our lease. We talked with our landlord, got out of our lease. We took our computers in the backs of our cars and went home, and really just had to figure it out. And I've been working from home ever since. I never went back to the office full time like a lot of people. I have a little office set up here. You can see some of it. I won't let you see all of it right now because I got Christmas stuff everywhere. But we realized, though, early on, because we had to move everything online. I was basically, we stripped, the law firm was down to basically me and a partner. We were running basically a solo shop with 2 attorneys. And We were doing everything. We had to figure out, okay, we don't have anybody going to the bank anymore. What do you do? Oh, well, the bank has electronic check deposits. Okay, well, we'll get one of those. We had one office that we were paying just a few $100s downtown to have all of our mail sent to, so somebody could go check the mail every few days. And then we started trying to avoid getting mail as much. In Georgia, in civil practice, the good thing is a few years earlier, everything moved to online electronic filing. So basically, all of your correspondence, you weren't getting these massive discovery packages anymore in the office. Everybody was just emailing everything. Like we finally realized it was 2020. So we started progressively kind of moving more and more stuff online. I got tired of writing checks. I was doing all of the accounting and the check deposit and everything, and realized there's an app for that. It's called bill.com. And we enter the information in there, and then bill.com mails the person the check, and it takes it directly out of our bank account. Wow. That's great. And then we've continued to use that for the last few years. So now we almost never write a handwritten check in the office, and it makes the accounting so much easier because it's literally linked to your bank account, and the funds get to your client way faster than a check in regular mail. The other thing is we realized clients stopped coming into the office. We used to always insist that people came to the office and we have a face-to-face. I have not met a client face-to-face for an initial consultation in probably 3-4 years. Some attorneys, if they're local, they'll want to meet up. But I find that people have been in accidents. They've got to go to all these doctor's appointments. They have to, all these places they have to be. If they don't have to come into your office and we can do this on the phone or a Zoom call, they're going to jump at it because they don't want to be inconvenienced with having to take more time off of work or time out of their day to go to your law office and sit with you in the conference room. There's no need for it. People aren't bringing in massive amounts of paper anymore. Everything's just emailed to us. The accident reports are available online. Everything is available online, and we really encourage our clients to give us everything electronically, and it's a relief to them. It's kind of like, I tell people, it's like if you bought a house in 1999, it was probably a lot different than buying one the last few years, right? And I tell my wife, like, when I bought my first house, I'm almost 49. I bought a house when I was about 27, back when you could buy a house for $100,000. That's how long ago this was. So, you went to the bank, you made an appointment to meet with the lender at the bank, right? And there was an office upstairs with all the lending people were, and you had a pen that was real fancy, and you signed all the paperwork, right? And then you started making trips to bring that guy all your documents. And so you would get your tax returns and everything printed out, and you would find this, that, and the other, and you would make another trip over there and drop off all these documents. Well, now when you buy a house, you call, you Rocket Mortgage or one of these apps. I contacted 4 of them to get a rate. I got the one with the best rate. They sent me an email. I dropped all my paperwork in there, and I was done. Nobody ever met face to face. I never had to make an appointment to go to anybody's office, and it was a way better experience. It was just so convenient. So I think most law practices that I know of, some people are just dead set on wanting to have clients come in as much as possible and develop that relationship. And I do think that's important. And I think something can get lost when you don't do that. But for the majority of people, it's a transaction, and they want it to be as uninhibited as possible. Like, they want it to be as painless as possible and take as little time as possible, because the ultimate goal is they want to get compensated for what they're having to go through, and they know it's going to take a few months to get it at the minimum, and they just want it to be over as soon as possible and put the money in their bank account. But we usually, when we do meet people now, it's depositions, it's things like that. But also, depositions have moved online. I do very few depositions in person, and the benefit of that is that clients don't have to come to the office. You don't have to get sometimes 2 or 3 different law firms to be in the same place at the same time. Inevitably, somebody has to cancel and you have to reschedule. Now we're just on Zoom. I've got one tonight at 4:30. I have one tomorrow at 10 o'clock. They're all on Zoom, and it makes life so much easier. And, I'd never even heard of it. I don't even know if we would have known a Zoom deposition was legal, right? Because there was this issue of, does the court reporter have to be in the room to swear you in? Can you do it remotely? Like, it was a real gray area. Whenever you had somebody out of state and you had to do their deposition, you weren't sure that it was even legal, right? And you probably would have faced a motion to have it excluded because the court reporter wasn't present. So, COVID cleared up rules on that, and now they're almost exclusively done by Zoom or some
Yeah,
equivalent.
that's it was kind of just forced upon everybody, so we all had to adapt to it and realized, "Oh, this is fine. We can do a lot of this, remotely." What about for like court status calls? I mean, they used to call them cattle calls, and then all that kind of moved electronically as well.
Yeah.
Is any of that still present in your practice?
I mean, it is rare that you actually have to be physically present in a court call. I think the judges realized it was way more efficient and easier on them if people just checked in remotely. A couple of the local courts might require an in-person appearance, but I think I go to 2 a year, and we probably have, 30 to 40 cases in litigation in a year. Not a huge amount, but I used to spend a good part of my practice on the road driving around the state to depositions and calendar calls. And especially if you had a case go into trial, you'd have to drive up there for the pretrial hearing. You'd have to drive up there for the motions hearing. You'd have to drive up there for your first calendar call, and then the case just gets continued. So it was putting a ton of miles on the car, just kind of, doing not really a lot of substantive work on the cases, just having to be where you needed to be. And that really got eliminated after COVID. Like a calendar calls now, anything, a status conference, things like that, it's always on Zoom or a phone call now. And thankfully, most of the courts, most of the judges have a preference for that as well, because they've realized how easy it is. I mean, even your motions for summary judgment, they're usually not in person. They can be, just kind of depends on the court's preference. I think something like that now, you're more likely to be in court, but we really rarely have to drive anywhere for a deposition. It's not, it used to be something I did almost every week, and I was getting really tired of it. And so that caused an opportunity. We realized once we started doing all this on Zoom, everything was being done at your desk. And we realized that we could take cases in places where we probably would have thought it'd be too inconvenient to take a case, and we'd need to give it to a local attorney. I just settled a case that my partner brought in for, I think we worked on it for 4 years. It was out of Dade County, which is extreme northwest Georgia, right on the Tennessee and Alabama border, right in that corner up there. We're on the very end of the state. I mean, it's a good 6-hour drive from our main office. But we had a local person in Savannah that was struck by a drunk driver up there. And we settled that case at a Zoom mediation about 2 weeks ago. We did an in-person mediation in Atlanta that was last year that was unsuccessful. And we did the Zoom mediation that went a lot better. And we were like, look, we're not going to drive all the way up to Atlanta again. The court's ordering us to mediation. We'll do it by Zoom. But I think maybe we made one trip to Dade County in the 3 years that we had that case. And, 5 or 6 years ago, I don't think that would have been possible. It would have been a real pain in the neck to have a case that far away without local counsel available to cover some of the preliminary hearings and things like that you inevitably have to go up there for your depositions and whatnot. Just now, it was no problem at all now.
Well, good. So, Ben, where do you guys get the majority of your cases from? You mentioned the kind of the cost per click is getting pretty high and is probably going to get higher as far as personal injury cases are concerned. Where are you guys seeing the most traction in your marketing efforts, and how do you get cases?
I get a lot of referrals. We built our practice primarily on referrals. We depend less on that now, but honestly, there's no reason not to. I mean, we need to build up our referrals. That's something that is also you have greater potential now for, because you can get referral partners that aren't just the local attorneys. You can go get referral partners, 3-4 hours away. One of our biggest referral teams is a general practice lawyer that didn't do personal injury in my hometown in Habersham County. And, I think we've had over 30 or 40 cases referred by their firm in the last few years. Now, the goal is to try to get many more of those. And the great thing about it now is that, you can pretty much just pick a town anywhere in Georgia and reach out to attorneys there to refer you cases. And it's just a matter of putting in the time that it takes to build that relationship, make the connection. The other things that, we run some billboards. Personal injury is one of the weird practice areas where it's actually cheaper to put up a bunch of billboards than it is to advertise online. We run Facebook, that we do a lot of social media. That's something we're really ramping up. My partner's wife, Andrea Jarrett, has a lot of experience in that type of thing, and she's joined us. And so we kind of have somebody that's in-house that's dedicated to that. And I think that is hugely important now. I mean, I think I'm really jealous when you go to conferences and you see what other people are doing with their social media, and you're just like, man, this is really the future. That's the way to get cases. And, PPC, pay-per-click, is definitely the easiest way to get cases, but it's the most expensive way. So if you can't match the budget of the people who are dominating that space, which we have now a $1 billion law firm in Morgan & Morgan, that's in almost every state. I think they're in over 30, and they're definitely all over Georgia. It's hard to compete. You got to be one of the 2 or 3 people popping up there, and their margins are just, they can afford to pay a lot to get a case. And, I don't want to be paying $3,000 per case just to get a case in the door. So, if I get one on social media, I'm usually paying, maybe $100, and, I don't get as many, and I got to work harder to get it. You got to put more time into it. And it's not just like run the ad, the phone starts ringing in an hour, which was what happens with pay-per-click. But, you can nurture people online, get people coming back to you, being in their social media over and over and over again. And there's some tricks to that we're learning to be more effective with it. And I think that's probably where we're going to spend a lot of our dollars in personal injury, is just trying to be visible online, especially with the people in the Southeast Georgia region, North Atlanta, where we have offices. You just want to be present in their online space as much as possible. And right now it's very inexpensive to do that.
Yeah. And how about for the immigration type of cases? Is it the same?
Same thing. Same thing. Now, we run pay-per-click on immigration. It's a lot cheaper. I mean, it's just not nearly as competitive. I think I told you before we started recording, almost every other practice area besides personal injury, you're paying anywhere from $5 to $30 per click. Personal injury in Georgia is routinely $200 per click. So, you can run a much smaller advertising budget and get the phones, coming in and the cases coming in the door. Not always as easy to convert. Sometimes you have too many coming. You just can't keep track of it all. It's like you have the problem with personal injuries. You spend money, you still don't get as many cases calling as you want, but you convert all the ones you can. And then you have other practice areas that are more high volume, but you're missing people because you got so many of them calling, so it's a double-edged sword. And it's just kind of a balancing act that we're always kind of juggling. But I really, we realized a couple of years ago that there were other practice areas that were way less competitive to get started in, and you didn't need a huge budget or go get out a big loan to pay for your advertising cost. That, you can get money coming in the door and build a valuable practice that's an asset to the firm that you can scale.
Looking forward, Ben, where do you see your firm going in the next 12 to 18 months? Do you have any big shifts on the horizon, or where do you see your practice going moving
Yeah,
forward?
I mean, I think that we're always going to be doing personal injury work. I mean, that's just kind of the thing that I enjoy working on the cases. And we're going to continue to try to grow that practice as much as possible. We're now taking cases in Texas. We're taking cases throughout the state of Georgia. Growing that caseload is our primary goal. In order to assist with that, we want to look at other practice areas that, again, the entry to get the cases flowing in is not so expensive. We always are going to need a big advertising budget on personal injury. So what are some cases we can have a much smaller advertising budget? It's not going to eat into that very much, but we can get revenue coming in. And so, we're definitely looking to expanding our immigration practice into employment immigration, things like that we just haven't done in the past. We're looking at possibility in deportation defense. I think having a big suite of services in immigration is something that we're looking into doing, because you can do that as a multi-state practice as well. So it has a lot of potential. You can, because it's all federal law, you can, practice it in other places easier. Right now, we're just practicing Georgia, Texas, because we have a bar license in each one of those states. So and there's plenty to go around. Like, we could increase our budgets dramatically and never have to leave those states. So I think that's probably where we're really going to focus, is trying to grow another revenue stream from, adding up employment immigration, definitely. And then look at some other things. I think everybody should consider it. I've met a lot of people in estate planning that seem to be doing boom business right now. I think it's a really great time to be in that field. Baby boomers are all retiring, and they own more property than anybody in the history of the world. And they've got to have a plan for what's going to happen with all of this stuff. I think estate planning is going to be, for the remainder of my career, probably a very a good time to be in the estate planning business. I wish I knew anything about it, because I'd be doing it right now if I did. So got to find somebody that knows how to do it.
Okay, so would that be the strategy then, to find somebody that knows?
Yeah, I think one thing we've learned is it's really easy to add a practice area if you can find somebody who's been doing it for a few years at a minimum and can just take it over and run it. We wasted a lot of time trying to educate ourselves as the law firm owners on how to do, like, it was a mentality that if we didn't know how to do every bit of it, like, we didn't need to be doing it. Well, these big companies, like, what are Troutman Sanders and all of these places that are these, these huge laws, do the partners at those places know all the ins and outs of every type of practice that they offer? No. We've got to have senior attorneys come in to start practice areas with us and report to us, and we oversee them. But, we're not going to be really involved in the day-to-day of that. And that's just kind of a mentality change that I don't think we had for many years. I think for many years, we're the partners, we need to be doing the bulk of the work. And that's really not the way to grow a practice. I think you've got to find other people who can report to you that are doing a lot of the day-to-day, and you can be involved in the major decisions. But, if it's bankruptcy or these other things, the idea that I need to spend time learning the ins and outs of that. No, I can have a senior attorney come in and be responsible for that and report to me and my partner, but they're the ones that have the knowledge base and the know-how to keep that running and get it going. So that's something I think that in the next couple of years, we want to identify other practice areas that we think have good potential. And, our job is to make sure we can get the cases coming in and we can give them stuff to work on. But ultimately, they're the ones that are going to be, responsible for the day-to-day.
Yeah, that makes a lot of sense. Ben, where can our listeners find more about you and your firm?
Well, we have a YouTube channel. We have Facebook pages, Jarrett and Price. Just Google any of that or whatever your search engine of choice is nowadays. And we try to be pretty omnipresent online. We have Jarrett and Price YouTube channel that's got content that's added to it on a semi-daily basis, several times a week. We're adding content. Shout out to my partner and his wife. Patrick Jarrett does a lot of that work. I assist when available. I talk on these things, but basically my job is to turn the camera on and start talking, and everybody else does all the other work. And, that's a great way to find us. We've got Facebook ads running all the time. We're about to start doing TikTok on almost daily basis. Just be easily found. I mean, that's the main thing. I think there's all these platforms now, and there's only going to be more and more of them. I just think that's the way people find you. We used to joke, we had to do that for so many years because we didn't have a sign. So many law offices, you've got like this little sliver of a sign, and a bunch of others. You're like, nobody's ever seeing that. Nobody's driving by and seeing your little sliver of your name and phone number on there,
You mean for
So
$250 a month, they didn't include a big
no, we didn't even have a
sign out
sign.
front?
And then we started paying a lot more. We still didn't have a sign, Signs were hard to come by. So we always we're online since the day we opened the doors. It's the way we got business. We did a lot of family law in the first 5 or 6 years of the law firm, and we realized, man, you put up a website and you start running some pay-per-click ads and figure that out in an afternoon and a day, and you can get your phone lines humming. And we did. We built our practice with a totally in-house team, we were adding clients on a weekly basis and really started from there. And now we have a marketing company that helps us a lot of that. But we've sort of now come back and now we're doing more of it in-house. When Andrea joined our law firm, I mean, yeah, that was kind of the expectation, and she's doing that. We have our marketing teams doing ads and doing things online, but we're doing stuff as well. So we get, you know, double bang for our buck. And I just think as busy as you can be online and be as omnipresent as possible, that's the way people are going to find you these days. I still run billboards. I still get a lot of people that say, "Hey, I saw your billboard." I'm just on a daily basis. I think billboards are great. I think they work, but I don't know that people know what we do, right? I think that because we're showing up in their social media, they have a much better sense of what we're doing and what we're all about.
Thanks so much, Ben, for taking the time with us today. I want to be respectful of your time. Appreciate you being so transparent and lifting the curtain on your practice.
Thank you so much, Adam. I really appreciate the opportunity.